Let's come to order and go on the record. Today is Friday, September 9th. It is the final day of the Evergy Metro and Evergy, Missouri West general rate case hearings. My name is Charles Hatcher. I am the regulatory law judge presiding over this hearing, and I have no morning announcements to make.
Judge, Commissioner Holzman's joined.
Thank you, Commissioner Holzman. We will make sure and note that for the record. And we have two issues scheduled for today regarding the Central Nebraska Public Power and Irrigation District Hydro Purchased Power Agreement is the first. And the second issue I have is deferment of the FAC costs from case 0011, file number ending in 0011. The full file number for the record is ER-2022-0129. We will start with mini opening statements, and we will start first with the company.
Good morning. May it please the Commission. This issue revolves around a purchase power agreement that serves Evergy, Missouri Metro customers. The 60 megawatt PPA is with the Central Nebraska Public Power and Irrigation District. You'll see it referred to as CNPPID. And instead of trying to say CNPPID over and over, I will refer to the PPA as the Hydro PPA. The Hydro PPA began in 2014, was fully included in the company's cost of service in the 2014 and 2016 rate cases. The company staff and OPC agreed in a settlement agreement in the 2018 rate case that the Hydro PPA would be removed from the company's fuel adjustment clause calculations due to staff and OPC concerns with the contract price. That stipulation did not exclude the Hydro PPA from being included in base rates. Lynette Nunn testifies in this case that the Hydro PPA was included in base rates in the 2018 case, and the excess of the cost of the contract over market rates were excluded from the FAC pursuant to the stipulation. This approach allows the company's FAC to reflect costs attributed to the service provided by the Hydro PPA, but reflects those at market prices rather than the price of the Hydro PPA. Today, in this case, staff has removed the Hydro PPA from its base rate calculation. It's removed it entirely without providing for costs to serve the load that the Hydro PPA was expected to serve. What this means is staff removed the costs and revenues from the company's cost of service, but it didn't take the next step of adding the cost to serve the company's load that was formerly served by the PPA into the company's cost of service. In other words, by fully removing the Hydro PPA from the cost of service, staff has left the company short of recovery. Company short of recovery to serve its load under staff's approach. This, we believe, is unreasonable and inappropriate. To be clear, the treatment that we are asking for in this case is to retain the Hydro PPA revenues and costs and base rates, retain the adjustment to market prices for the Hydro PPA and the FAC tariff, consistent with how it's been done in the last case and how it's been handled since the last case. It's also consistent with Missouri customers only paying the market price for energy supplied to load from the Hydro PPA and not the full contract price. If the Commission decides to eliminate the PPA from the cost of service, instead of allowing the process to remain unchanged from the last 4 years, Evergy, Missouri Metro estimates this shortfall would be worth at least $3.2 million using market prices with staff's model, and $4.5 million shortfall if treated consistently with the way it was done in 2018. At the very least, the commission must add at least $3.2 million to Evergy, Missouri Metro's cost of service so that its base rates reflect the cost needed to serve its customers. I really encourage you to ask questions of witnesses Linda Nunn or Jesse Tucker to get the details of staff's improper adjustment and how the company proposes to handle the hydro PPA. Now, you may hear from staff and OPC that nothing needs to be added to the company's cost of service after removal of the hydro PPA, since the company is long on generation and will be able to cover its needs with additional generation. And the company agrees it is in a long generation situation, but it's important to note that it's not long every hour of the day or during every market condition. Staff and OPC's long on generation argument doesn't reflect the realities of the SPP market or Evergy, Missouri Metro's operations. And for this reason, staff's cost of service number should be adjusted to include the cost of the hydro PPA and retain the FAC tariff as is currently stated. Staff's cost of service number must be increased by at least $3.2 million to cover Evergy, Missouri Metro's cost at market to serve its load. Now, anytime the company is long energy sales in the market, the actuals will flow back to the customers through the FAC as appropriate. In closing, because of staff's improper adjustment, Evergy, Missouri Metro's base rates are millions of dollars lower than necessary to serve customers, and the company urges the commission to correct staff's unfair penalty.
Thank you, Mr. Steiner. Are there any commissioner questions for Evergy? Hearing none, the bench has none. Thank you, sir. We'll move on to our next mini opening statement on this issue, and that would be staff. We have an introduction before that begins.
Good morning, Your Honor. May it please the Commission. This morning I'm here to introduce Scott Stacy, new to the Staff Counsel's Office, but not new to the practice of law in Missouri. In fact, he has previously worked with the Missouri Attorney General's Office, the Missouri Department of Natural Resources, the Cole County Prosecutor's Office, and he has private practice experience as well. So this morning I'd like to introduce Scott Stacy.
Welcome, Mr. Stacy. The floor is yours.
Thank you. Good morning, Your Honor. Good morning, Commission. May it please the Commission. Again, my name is Scott Stacy. I'm attorney with Staff Counsel's Office. Here today to testify will be Brad Forson, who will testify about the hydro PPA. Sean Lang will testify about the fuel model regarding that PPA. Staff witness Forson will testify regarding whether the cost of central or the hydro PPA should be recovered from Missouri customers through the company's fuel adjustment clause, FAC, the FAC base factor calculation of the revenue requirement of Evergy Metro. Staff witness Sean Lange will testify that he did not include the PPA in the fuel run model. Because the PPA was entered to meet the Kansas Renewable Energy Standard, or RES, and is not needed to meet Missouri customers' load, staff's position is that it should not be recovered from Missouri customers. As such, staff did not include the costs and revenues associated with the hydro PPA in its calculation or its EMM's variable fuel and purchase power expense in this rate case. Staff asked the Commission to adopt staff's position regarding the staff's hydro purchase power agreement by excluding the costs and revenues associated with that PPA from the company's FAC and base rate calculations. Thank you.
Thank you, Mr. Stacy. Are there any commissioner questions for staff?
No questions, Judge.
Thank you, Commissioner Holzman. Thank you, Mr. Stacy. Welcome again. Mr. Opitz with MECG, do you care to make an opening statement?
I'll waive an opening statement. Thank you.
Thank you. And correct me if I am wrong, I believe we only have 4 parties involved today. Everyone else has been excused. Mr. Kleiser.
May it please the Commission, John Kleiser again. A well-recognized doctrine of rate making is the cost causation principle. The principle states that costs should be borne by the party who causes the costs to be incurred. Evergy Metro entered into the Central Nebraska Public Power and Irrigation District Purchase Power Agreement, which I will refer to simply as the PPA, in order to meet the renewable energy standards imposed by the state of Kansas. Under the cost causation principle, because Kansas caused the cost to be incurred, it is Kansas customers who should bear those costs. This is the basis of the OPC's argument. All we are asking is simply and solely that Missouri customers should not be asked to pay for costs incurred to serve Kansas. And I want to stress this to the Commission. You just heard counsel from Evergy come up and tell you that if you don't include this PPA, there will be a shortfall. But that's not true. They will collect the full amount of this cost from Kansas. The OPC is not asking the Commission to make a prudency decision. We are not asking the Commission to determine whether it was right or wrong to enter into this PPA. We are not even asking that they not be allowed to collect the cost of this PPA. We just want them to collect those costs from Kansas. And it's important to recognize that Kansas has a statute that says, by law, that they can recover 100% of the costs incurred to meet the renewable energy standard imposed by Kansas in Kansas. They have a law that will allow them to fully recover these costs in Kansas. There is no question that Evergy can fully recover the cost of this PPA from its Kansas customers. There's no question it was entered into because of its Kansas customers. This is not a loss to Evergy. This is not a penalty. The OPC is just asking to change who pays the bill, and it should be Kansas. Our position is again consistent with the staff of the Public Service Commission. And once again, I ask the Commission to ask any questions to either staff or OPC witnesses. One last thing I think I should mention, there was a discussion of the 2018 stipulation and the idea that it did not exclude the PPA. It did not include it either. It was black boxed. There is nothing in the 2018 case that says that this is included in the rate base, and it is a violation of the terms of the stipulation to argue that it is in and that the OPC is prejudiced by the 2018 stipulation. And we will discuss that on the stand as well. Are there any questions?
Are there any commissioner questions? Hearing none, I'd also like to note for the record we have been joined by Commissioner Glenn Kolkmeyer. We have on our WebEx both, Commissioner Jason Holzman and Commissioner Glenn Kolkmeyer. The bench has no questions. Thank you, Mr. Kleiser. That concludes our opening statements. Next, we will move to testimony, and the first witness will be from Evergy. Evergy is calling Linda Nunn. Ms. Nunn, please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Evergy?
Yes, thank you. Please state your name for the record.
Linda Nunn, N-U-N-N.
Ms. Nunn, where do you work,
Evergy.
and what's your position?
I'm the Manager of Regulatory Affairs.
Did you cause to be filed in the Evergy, Missouri Metro case direct testimony, which was confidential, which has been marked as Exhibit 63, direct public version, which has been marked as Exhibit 64, rebuttal testimony, which has been marked as Exhibit 65, Surrebuttal and True Up Direct, which has been marked as Exhibit 66, and True Up Rebuttal, which has been marked as Exhibit 67.
I did.
And did you file in the pre-file in the Missouri West case, direct testimony, which has been pre-marked as Exhibit 120, and that's the confidential version, and 121, the public version?
I did.
Do you have any changes or corrections to any of the testimony that I mentioned?
I don't.
Is the testimony true and correct to the best of your knowledge, information, and belief?
It is.
I would like to offer the testimony, direct rebuttal, surrebuttal, true up rebuttal, that is none filed in both cases into the record.
You have heard the motion by counsel. Those are 7 exhibits. I need not repeat the exhibit numbers. Are there any objections to the admission of those exhibits? Hearing no objections, so admitted. Go ahead.
Your Honor, the company tenders the witness for cross-examination.
Thank you. And on my schedule, we will go first to MECG. Mr. Opitz.
No questions, Your Honor.
Thank you. Next, we go to Mr. Stacy for staff.
Thank you, Your Honor. I just have a few. Good morning.
Good morning.
Is the hydro PPA needed to meet the Missouri res compliance?
It's my understanding that it is not needed to meet the Missouri res requirements.
Can the hydro PPA be used to meet Missouri res compliance?
Can it be?
Yeah.
I don't know that answer.
Okay. Is the hydro PPA needed to meet Effigy Metro customer load
It is used to serve customer load, yes.
for Missouri?
Yes.
Now, is the agreement covered by Kansas law?
It's my understanding that that law has changed. It's now voluntary.
And when does that agreement expire?
The PPA agreement,
Correct.
I believe it expires in 2023, outside of the true-up time for this case.
And the agreement can be renewed for 5 years, is that correct?
I don't know the answer to that.
Nothing further at this time, Your Honor.
Thank you, Mr. Stacy. And Mr. Kleiser.
No questions, thank you.
Thank you, Mr. Kleiser. Are there any commissioner questions for Ms. Nunn? All right, hearing none. I'm sorry, I do have some questions, and I just need a second to check. I have questions about the tariff sheet. Is that going to be Witness Tucker?
No, that would be me.
Okay. My questions are on currently effective tariff sheet PSC Mo number 7, fourth revised sheet 50.20. I'm going to hand a sheet to the witness and try. I'll ask Mr. Stacy to come up and distribute the other copies to council.
Thank you.
Thank you, sir. I think this has already been asked, but I want to make sure that it's on the record. If not, does Evergy, Missouri Metro include the hydro PPA costs and revenues in the determination of the FAC base factor in the current case?
The PPA costs have been included in the base factor since the PPA was initiated, and since rate case came after it was initiated in 2014. So 14 and 16. And then in the 2018 case, we stipulated no FAC. The way we take it out of the FAC is written in the tariff, but the base rate is included in the calculation. Yes.
Okay. Is the FAC net base energy cost and base factor included in the calculation of the fuel adjustment rate? The FAR, commonly.
It is a portion of that calculation. We take actual costs as compared to that base rate times actual usage, and that base rate does include that PPA, yes.
Thank you. That's all of the questions I have. You're not excused yet. I am sorry. My questions are going to submit us to a round again of cross and redirect. So I refer back to my order of cross. We go first to Mr. Opitz,
No questions, Your Honor.
Mr. Stacy,
I have one, Your Honor. This was a black box settlement, correct? On the PR,
Except for the fact that there is a section that stipulates about the hydro PPA.
and the hydro PPA is not in the FAC, is that correct?
It is eliminated, it is removed down to market value according to the tariff in the FAC.
Okay. Nothing further, Your Honor.
Mr. Kleiser?
I'd like to mark an exhibit. I believe my number should be 332.
So marked.
Ms. Nunn, are you familiar with the document I've just handed you?
Yes,
You would agree with me that this was the non-unanimous partial stipulation and agreement entered into by parties in the last Evergy general rate case?
yes,
You would agree with me that on page 1, under revenue requirement, it states what the revenue requirement adjustments for the case will be? I don't need to read the exact numbers.
it does have a list, yes.
You would agree with me that it states this stipulation resolves the following issues in the September 12, 2018 corrected list of issues filed in this case?
Yes,
And that at the end of that list, it includes item XXXV, CNPPID Hydro Purchase Power Agreement.
it does. It also has the fuel adjustment clause
We're going to
listed.
get there. You would agree with me that as far as the revenue requirement inclusion, there is nothing that specifically states whether the hydro PPA is included or excluded from this agreement.
This agreement says specifically that it's excluded from the FAC.
As far as the revenue requirement that was agreed to in this case, the hydro PPA was neither excluded nor included, but just considered a settled issue, correct?
Unless you take into consideration the tariff sheet that includes the base rate calculation right, that includes the base rate.
Did any party in this agreement agree to including the FAC in the revenue calculations as indicated on subsection 1 of this agreement?
That subsection does not specify that.
And if I turn your attention to paragraph 24 on page 12, you would agree with me that it reads, "This stipulation is being entered into solely for the purpose of settling the issues/adjustments in this case explicitly set forth above. Unless otherwise explicitly provided herein, none of the signatories to this stipulation shall be deemed to have approved or acquiesced in any rate-making or procedural principle, including, without limitation, any cost of service methodology or determination, method of cost determination, or cost allocation, or revenue-related methodology." You would agree with me that that's what the provision reads?
That's what it says.
Now, turning to the actual FAC section, or actually, yes. Turning to page 8, paragraph 14. You would agree with me that it reads, "KCP&L agrees to exclude the costs and revenues associated with the CNPPID Hydro Purchase Power Agreement, prin, quote, PPA, quote, end prin, for KCP&L's FAC calculations and shall file a separate tab in its monthly FAC monthly reports showing the CNPPID Hydro PPAs, including monthly operational data, costs, and revenues." You would agree with me that's what it reads?
That's what it says, yes.
You would agree with me that nothing in this provision explicitly sets forth a party's agreement that these costs will be included in base rates?
I believe the tariff indicates if you have to make an adjustment, there has to be something there to adjust from. And the tariff is specific about removing the contract costs and moving it to market.
Is the tariff part of this agreement?
I think the tariff isn't, it's my understanding that tariff trumps this agreement, right? I mean, you have to follow the tariff as you move forward. And I'm saying that it indicates that there has to be something in base or you wouldn't have to, the tariff language would be unnecessary.
The tariff doesn't explicitly state that it's in base. Your argument is it's implication, correct?
That and the work papers that were the support for the tariff.
Your work papers from the last case.
Actually, it was staff's fuel run.
Regardless, the parties did not agree to those FAC work papers in this agreement, correct?
I'm going to object that that's asking for a legal conclusion. A witness can answer if she knows.
I'm not sure, well, I'll say it and then you can tell me if I'm allowed to or not. In the discussions that we have at the end of the case where we develop the tariffs, we work together on how those costs got put together and how the base rate was set. As well as this wording in the tariff. And I should point out, it's been 4 years that we've been implementing this tariff language.
There is nothing in the tariff that is filed that says that the hydro PPA is in the base, correct?
Correct.
All right. I would move for the admission of 332, which I will title ER-2018-0145-0146, non-unanimous stipulation and agreement.
You've heard the motion by council. Are there any objections to the admission of Exhibit 332? Hearing none, it is so admitted.
I have no further questions. Thank you. I apologize. I missed it. Was that admitted?
332, yes.
Yes, sorry.
Redirect.
Thank you. Do you recall speaking with a judge about the tariff sheet?
I do.
And I think you said that that tariff sheet shows that I think you said that the PPA is included. Do you recall saying that?
The underlying work papers that produce that tariff, the FAR tariff calculation that happens every 6 months would show the inclusion of the hydro PPA in base.
And then, when you were speaking with counsel for OPC about the stipulation, do you recall that?
Yes.
And could you point out in your testimony where you analyze or provide an analysis where you believe that the tariff that resulted from that stipulation shows that the hydro PPA was included in the FAC base factor?
I provided as support to my testimony the calculation of the base rate in the 2018 case. And my testimony discusses the fact that that calculation has the hydro in it, ties to the net or the base factor that's included in the tariffs, as well as discusses the language in the tariff that says you need to make a comparison and reduce it to market or change it to market.
And just specifically, where is that in your testimony? It's your surrebuttal, is that right?
Yes, it was Sir rebuttal, and it was page 7 is where it starts.
Thank you.
Thank you. Ms. Nunn, you are excused. I believe Evergy has another witness.
Company calls Jessica Tucker.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Your witness.
Thanks. Please state your name for the record.
Jessica Tucker.
Ms. Tucker, where do you work and what is your position there?
I work for Evergy. I'm the Senior Manager of Fuels and Emissions.
Did you cause to be filed in this case, and it's going to be, there's a long list here, so please bear with me. Direct testimony in the Evergy, Missouri Metro case, which is confidential and been marked as Exhibit 74. Direct testimony public, which has been marked as Exhibit 75. Rebuttal testimony, Exhibit 76, that's confidential. Rebuttal testimony public, Exhibit 77. Surrebuttal and true-up direct, confidential, 78. Surrebuttal and true-up direct, public, 79. Rebuttal, confidential, true-up rebuttal, confidential, which has been marked as 80. And true-up rebuttal, which has been marked, true-up rebuttal public, which is marked as Exhibit 81.
I do not have the numbers to reference, but yes, I did.
And then in the Evergy, Missouri West case, did you file confidential direct, which has been marked as Exhibit 126, and direct testimony public, which has been marked as Exhibit 127?
Yes,
And today you are going to adopt the testimony of Eric Peterson, is that correct?
correct.
And that testimony was filed in the Evergy, Missouri Metro case The direct confidential was 68, the direct public was 69, and the public rebuttal was Exhibit 70. And in the Evergy, Missouri West case, the direct testimony was Exhibit 122, that's confidential, and Exhibit 123, that was the direct. Did you, are you adopting that testimony today?
I am.
Okay, thank you for bearing with me. Are the answers contained in that testimony, the testimony I just mentioned, true and correct to the best of your knowledge, information, and belief?
The data and the conclusions are accurate to my knowledge. There were a number of references to Evergy, Missouri Metro that should have been Evergy Metro, that had I had the opportunity to rewrite the testimony, I would have made those corrections. And the reason for that is based on how fuel operates and the fuel model. That all operates and is modeled at the metro level and then is allocated after the fact down to the jurisdictions. So the references in some cases to Missouri Metro should have been Metro because it was a modeling or a fuel procurement, that type of information.
Okay. With that, Your Honor, I'd offer the admission of the testimony that I raised, that I mentioned earlier.
Thank you. You have heard the motion by counsel. The list of exhibits as read by counsel matches the list of numbered exhibits on the presiding officer's list and will not be repeated because we already have them read into the record. Are there any objections to all of the admission of all of the exhibits just read into the record? I see perhaps a question. Hearing no objections, they are all so admitted.
All right, I would tender Ms. Tucker for cross-examination.
Can I back up for a second? Her correction is that some of the references.
I don't mean to interrupt your chain of thought. My question was just going to be if it was possible that Evergy could late file an identification of which were corrected.
These are witness Petersons that need the,
And Tucker.
okay.
It would be possible, Your Honor. We debated that. There's probably 50 or 60 references spread across all those pieces of testimony, and we were not able to get that done by today. We could very easily late file that with the corrections. Again, it's limited to references to Evergy, Missouri Metro. Should have been a reference to Evergy Metro.
I like that solution. Part of my announcements is going to be the final submission of any exhibits that haven't made the deadline by next Friday. So if a week is enough time to file those, excellent. If it's not,
That's enough time.
let me know. Okay. We are on cross-examination. Thank you. Let's look to my cheat sheet. And Mr. Opitz.
No questions, Your Honor.
I'm going to interrupt the flow to state for the record that all of the exhibits that were listed by counsel for Evergy are admitted pending their corrections and an appropriate shortened amount of time for objections in case some of those numbers will be substituted with a corrected version. And then let's move to cross-exam, Mr. Stacy for staff.
Thank you, Your Honor. Did you hear testimony previously from Linda Nunn involving Exhibit 332 from OPC, the non-unanimous partial stipulation agreement?
Yes, I did hear it.
And you did state in your testimony that you cited this agreement, is that correct?
I'm sorry, can you repeat that?
You cited this agreement in your testimony, is that correct?
That is correct.
Okay, and... Sorry. And in that agreement, it states on page 12, paragraph 25, no signatory shall assert the terms of this agreement as a precedent in any future proceeding, is that correct?
Are you reading from her testimony or the stip?
The stip.
counsel?
The stipulation, I'm sorry.
Do you need a copy of it?
Yes, please. Thank you. I'm sorry, that was page 12.
Page 12, paragraph 25.
Okay, I found it.
And then the last sentence, it says, no signatory shall assert the terms of this agreement as a precedent in any future proceeding, is that correct?
That is correct.
And the company was a signatory on this agreement, is that correct?
I believe so.
All right, nothing further, Your Honor.
Thank you. That brings us to Office of Public Counsel.
No questions, thank you.
Thank you. That takes us to commissioner questions. Are there any questions from the commissioners for Ms. Tucker?
No questions, Judge.
And
No questions, Judge.
Thank you, Chairman. You beat me to it. I would note for the record, we have been joined by Chairman Ryan Silvey. The bench does have a couple questions, if you'll bear with me. I want to reference your surrebuttal testimony.
Tucker?
Yes. Page 3.
Okay.
Lines 6 to 18 states that the stipulation that we are discussing does not exclude the hydro PPA from being included in base rates. For the record, what do you mean by base rates?
From being included in the revenue requirement?
How would this be included in the revenue? I understand it's an elementary question, but we want it
Yeah,
for
sure.
the record, so just as
Sure.
simply as you could.
So, excuse me, I am not an expert in the revenue requirement in FAC, but my understanding was that it clearly addresses the FAC, but it did not exclude us from including the hydro cost and revenues in our models to go into the revenue requirement in base rate as it had in 2018, according to my understanding.
And you would define base rates how?
Based on my knowledge, I would define it as the FAC base I'm sorry, I don't have the expertise to be able to
That's okay, I understand.
eloquently answer.
Let's move to is the FAC net base energy costs and base factor included in the calculation of the fuel adjustment rate. I already asked that. I already have that answer from Ms. Nunn. I also do want to note for the record, we have been joined by Commissioner Maida Coleman. That brings us to a total of 4 of our commissioners joined for this final day of the hearing. The bench has no further questions. That does take us through recross-examination, and we'll go back to Mr. Opitz.
Thank you. The judge was asking about the revenue requirement. Can you tell me what documents we would look at to see the items that you think are included in the revenue requirement?
So my testimony and Mr. Peterson's testimony covered the fuel and fuel modeling, which was incorporated into the CS24 work papers. There was additional work, I believe, done by regulatory to add information in there. And that portion, collecting all of everything in the revenue requirement, is outside of my ability to answer.
That's all I have. Thank you.
And staff.
No questions, Your Honor.
Public counsel.
As counsel for MECG pointed out, you were asked a question regarding the revenue requirement. Do you have a copy of what has been admitted as 332 in front of you?
This is 332, the,
Non-unanimous partial stipulation
I
agreement.
do.
And the first paragraph is the section labeled revenue requirement. You would agree with me there?
I would.
And you would agree with me that the first sentence of the first paragraph sets what the revenue requirement is for this case? You would agree with me?
Can you repeat that? I'm sorry.
Let me just read it out loud. KCP&L's revenue requirement will be reduced by 21 million. GMO's revenue requirement will be reduced by 24 million. You would agree with me that's what it reads?
I would.
And I didn't get this in earlier, but to make sure things are clear, KCP&L is identified in this document as Kansas City Power and Light Company. You would agree with me that Kansas City Power and Light Company is the predecessor to the current Evergy Metro, correct?
I would.
And GMO is identified in this document as KCP&L Greater Missouri Operations Company. You would agree with me that KCP&L Greater Missouri Operations Company is the predecessor to Evergy West, correct?
Evergy, Missouri West. I would.
Evergy Missouri West. Thank you. I apologize. And you would agree with me, turning back to the revenue requirement, that it further states, this stipulation resolves the following issues in the September 12, 2018 corrected list of issues filed in this case, colon, and then lists all of the issues resolved by the stipulation, correct?
I see. Yes, I agree.
Are you familiar with the term black box settlement?
Somewhat.
Can you describe what a black box settlement is generally?
My understanding of a black box settlement would be to, settlement would be to come to a number without necessarily delineating what all is included in that number.
You would agree with me that this provision is a black box settlement?
I'm going to object. That might cause her to give a legal conclusion.
Before I rule on this, Mr. Kleiser, I am aware that paragraph 1 leaves open to interpretation what's in or out of that number.
I'll withdraw the question. I understand, Your Honor. Thank you.
Thank you.
I have no further questions.
Okay, awesome. That resolves that. Redirect.
Just a minute, Your Honor. Ms. Tucker, do you recall the judge asking you about what is in revenue requirement?
I do.
Do you agree that the testimony of Linda Nunn would be the best place to potentially find an answer to the judge's question on that?
I would.
Thank you.
Thank you. I don't want to excuse Ms. Tucker quite yet. There's an exhibit that the commission is going to request. There's going to be two requests, but this one relates to what Ms. Tucker just testified to. The commission would be very interested in her work papers that include or identify the hydro PPA cost and revenues that she referenced.
Are you requesting a late filed exhibit of
Yes,
that?
yes,
Okay.
sir. And we will, I'll go ahead and make the announcement now. All of the exhibits will have a due date of next Friday. So any that weren't in pre-filed testimony or that have not already been submitted, so specifically this one and any others that happen to come up, the corrected testimonies, will have a submission date of next Friday and probably the following Wednesday for objections. And, yes,
Could I get a clarification, Your Honor?
please.
You say her work papers, is that for this case or for the 2018 case?
I believe her testimony was on the 2018, but I am not sure. I realize that if I ask the witness that due to keeping some rules of fair play, we're going to go all through cross-exam and redirect. Okay. Ma'am, were you testifying to your work papers in 2018 or for this case?
In regards to the hydro,
Yes.
the work papers would be for this case.
For this case, then, yes.
Okay.
Oh, may I also have 2018
Yes.
for both? Okay. So that will be,
So, Your Honor, just so I'm clear, the Tucker work papers, are you wanting none work papers as well?
I'm going to give a second for my email to catch up. Yes. Would Miss Nunn's work papers also be addressing in the 2018 and the current case how the hydro PPA was included?
I believe both would, yes.
Okay.
To be clear, we're saying how it was included from Evergy's perspective.
Yep.
Right. No other party is agreeing to those work papers.
I understand.
Okay.
But I understand, yes.
Your Honor, you asked Ms. Nunn about a tariff sheet. Were you meaning to mark that as an exhibit? It's a currently effective tariff, I think, so.
It's a currently effective tariff, and I was aware of everyone's email bounce back issues. So it's 148 pages, and that's going to fall into that next Friday deadline. I'm not sure how I want to handle that. I would be happy to take suggestions. I will file the entire tariff as a commission exhibit 1000. Also subject to objections. If you need to preserve any for the record, I certainly understand that. I don't think anyone has exhibit numbers in the 1000s, so Commission Exhibit 1000, the presiding officer will take responsibility for sending that electronically to all council and submitting it in the normal and proper channels. We're still on redirect. Does the company have? Oh, no.
No, I finished. I think you had a question on
did, and
18 or 14, so I think that's where we're at.
Yes, does anybody have any further questions for Ms. Tucker? Ms. Tucker, you are excused. Thank you. I apologize for the confusion. I believe we are now moving on to staff witnesses, if that's correct.
Thank you, Your Honor. Staff calls Brad Fortson.
Mr. Fortson, please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. Your witness.
Thank you, Your Honor. Would you please state and spell your name for the record?
It's Brad, B-R-A-D, middle initial J, last name Fortson, F-O-R-T-S-O-N,
And by whom are you employed?
the Missouri Public Service Commission,
And what is your position?
Regulatory Compliance Manager.
Have you prepared and filed testimony in this proceeding?
Yes,
Specifically, direct testimony on June 22nd, 2022,
yes,
and sir rebuttal testimony on August 16th, 2022,
yes,
which have been pre-marked as Exhibits 228 and 263, respectively. Is that correct?
correct.
Do you have any changes or corrections to make to any of those documents?
I do not.
If I were to ask you the same question in those documents today, would your answers be the same?
They would.
And are those the same answers true and correct to the best of your knowledge and belief?
They are.
I offers Exhibits 228 and 263 into evidence.
You've heard the motion by council. Are there any objections to the admission of those two exhibits? Hearing none, they are so admitted. Go ahead.
And I also want to clarify for the record that those are 228 and 263 are both public and confidential with the same number.
That's correct.
All right. I tender the witness for cross-examination.
Thank you. That'll go to Mr. Kleiser.
Good morning, Mr. Fortson.
Morning.
I'd like to start off rather basic. Are you familiar with the principle of cost causation?
I am.
I'd like to quote for you from a book titled Energy Utility Rate Setting by Lowell E. Alt, Jr. Cost causation is the principle that costs should be borne by those who cause them to be incurred. Do you believe that that's an accurate representation of the cost causation principle?
I do.
And you would agree with me that that's a principle that that this commission has ascribed to?
Yes,
I'd like to mark another exhibit. This should be 333.
So marked.
Now, Your Honor, before I go any further on this, I want to explain something. This exhibit, which I intend to ultimately introduce, is the data response the OPC received from Evergy in a prior case. The response itself, which is what I intend to cross Mr. Fortson on, is just the first page with the associated verification. The response included 3 attachments. I do not intend to cross Mr. Fortson on the attachments, nor did I intend to offer them. However, I did not want to be accused of not including vital information. I also did not want to be accused of trying to shoehorn in information that I was not crossing on. Therefore, I have given the attachments, which I will note 2 of which are confidential, and I will then, when I move to admit this, offer them at the company's or commission's discretion. But I'll get to that in a second. I just wanted to attempt to explain that. As far as I'm concerned, though, the document that I am questioning on is the 2-page item that I handed out. And with that, I will proceed. Mr. Fortson, are you familiar with this document?
I have reviewed this document before.
You would agree with me that this was a data response that the OPC received from Evergy, Missouri?
Yes.
You would agree with me that the question posed was to provide all documentation regarding the initial decision to enter into the contracts for hydropower?
Yes.
Now, I don't want to read this entire document into the record for everyone's sanity. Can you please just simply review the response? And you don't have to review the attachments, obviously, just the response here for a moment. Tell me when you think you've sufficiently reviewed it.
I think I'm good to proceed.
You would agree with me, based on this response, that Evergy Metro entered into the, what's the full name of the PPA? Central Nebraska Irrigation, I'll just say it, the CNPPID Hydro PPA, in order to meet renewable standards imposed by the state of Kansas.
Yep, that is my understanding.
All right, as I said before, I would like to offer Exhibit 333. And by offer, I mean specifically the 2 pages that make up the initial response and the attachment. I leave at the commission's discretion whether they would like to include the attachments, 2 of which, again, I will mark or note are confidential. I am not requesting that they be admitted, but am including them in the event that any party felt they were necessary.
Are there any objections or input to the commission receiving Exhibit 333 into evidence?
As far as title goes, I would offer OPC DR 8002.
So just so I'm clear, it's the, John, it's the 2-page document with the verification. This is what you're offering, not all this.
Correct. I did not cross him on the remainder, although I wanted to include it in case somebody felt the rule of complete evidence required it to be included.
I don't have an objection, Your Honor, for the 3-page.
Would your objection change if the commission said its preference would be for the entirety? If it does?
I just really hadn't had a chance to look at it, and I'm just, my eyes have glazed over when I look at it, so I could scan this one quickly. I couldn't scan this one quickly.
If I may propose a suggestion, since there's no objection to the admission of at least the 2 pages, can that be admitted and then the latter part treated effectively as a late filed exhibit and given, I believe you said Wednesday after next, time to object? That's, OPC has no problem with that.
That's a good idea. Let's handle that way. I think all of our I's are a little crossed at this moment. And to let everyone know, I have not looked at whatever information is in the attachments. I have no idea. My request is based in the fact that I typically get asked for an entire document, that there is opposition to receiving only a page of a thing. I'm not sure how far that ideology extends, if it's just the 2 pages, or there does seem to be some information in there. I will do my best to find out if I do have any requests, and I will email that to the parties if we can keep it with just the 2 pages.
To be clear, I was attempting to respect that. I just didn't also want to be accused of shoehorning in information that wasn't crossed. I will continue
I
my
understand
promise.
your concern that was raised earlier in this hearing. Are there any objections to the admission of Exhibit 333, which is the data response 2-pager? 2 pages of data response 8002 with the attached verification of response. Hearing none, it is so admitted.
I apologize.
No, you're
Because I'm
good.
about to ask to mark another exhibit.
I am going to hold off on the attachments to Exhibit 333, and I will follow up with an email to the parties if the commission does request that to be an exhibit. Go ahead with your next exhibit, Mr. Kleiser.
Should be 334.
So marked?
Question regarding the term of the contract that was listed in here. This contract is marked as confidential. However, the actual term of the contract is just.
Yeah, and it said it expired in
Yeah.
2023. That would make
So as far as I'm literally just going to ask him, I think, to identify where on earth this term went. Page 14. You're okay with me?
there, yeah.
Okay.
Or we can just stipulate that's when it expires, but if you don't want to enter all this.
Well, I'd like to.
That's fine.
I'd like to lay foundation. Thank you. Mr. Fortson, are you familiar with this document?
I have reviewed it before, yes.
You would agree with me that this is the response to an OPC data request filed in the last rate case?
It is.
You would agree with me that the attachment includes the actual contract between Evergy Metro and the Central Nebraska Public Power and Irrigation District?
Yes.
And just for the record, I will note that the contract is signed with Kansas City Power and Light Company. You would agree with me?
Yes.
And I know we said this earlier, but just for the sake of the record, that is the former entity now formally known as Evergy Metro, correct?
Yes.
Your Honor, I am going to ask a question related to the section of this contract. The contract has been marked as confidential. However, in discussions with Evergy Council, the section that I'm going to read, Council has acquiesced that it is not confidential, that small section, if you follow me. So I'm,
Yeah, I think you're asking about the term, and that can go on without being in camera. Are you going to make this a confidential exhibit, John?
it was my intention to introduce it, and I will ask that it be marked as a confidential exhibit to preserve its latency, confidential nature.
Okay.
Are there any objections? I'm sorry, did you move?
I hadn't moved, but since we're there, I guess I'll just go ahead and move.
I want to make this very clear on the record. Are there any objections to the admission of Exhibit 334 marked in its entirety as confidential?
No objections from staff, Your Honor.
Hearing none, it is so admitted. How the commission will handle this is there will be two 334s. One will be named the public version, which will show that it is confidential.
Mr. Fortson, turning to page 14 of the attachment.
Okay.
And under the section labeled 3.01.01, labeled term, starting at the second full sentence, you would agree with me that the term of this agreement shall begin on January 1st, 2014 at 12:01 a.m. Central CPT and shall remain in full force and effect until 11:59 p.m. CPT on December 31st, 2023.
Yes.
Now, you would agree with me that under Missouri law, an electric utility is required to return to the commission for a rate increase or rate case every 4 years in order to maintain its FAC, correct?
Correct.
You would agree with me that the general operating standard of the commission staff when, for example, choosing amortizations is to assume that electric utilities will stay out over a 4-year period, correct?
I believe so, yes.
If this contract is included in rates, you would agree with me that it will end before the expiration of a 4-year period, correct?
Correct.
You would agree with me that if it ends before the expiration of a 4-year period and is included in rates, the company will collect money that is no longer incurring, correct?
I believe that's correct.
I'm going to move on. I think I have one last line of questioning. I'm going to ask you a couple questions regarding settlement. I want to make this very clear. I am not asking you any questions related to any particular settlement negotiation. If for whatever reason you think that I'm getting into a particular settlement negotiation, please do not answer. Those are privileged. Please do not provide any response as to a particular settlement. I'm going to keep things general. Do you follow me?
Yep.
Have you been engaged in or at least participated during settlement negotiations?
I have.
Are you generally familiar with the concept of a black box settlement?
I am.
Can you please provide a brief description of what a black box settlement is in your terms?
Sure. In general, it would be an agreement, typically to a number that doesn't explicitly state how each party got to that number.
Have you, in general, referred settlement agreements entered into by parties before this commission?
Say that again, I'm sorry.
Have you, in general, reviewed settlement agreements entered into by parties before this commission?
Yes.
Would you agree with me that it is a general provision of settlement agreements that the issues decided, that only the issues decided by a settlement agreement are binding on parties and issues not addressed are not?
I would agree.
From your personal perspective, if you were responsible for settling cases, would you feel comfortable entering into settlement agreements in future if the commission were to determine that items that had been black boxed were in fact actually decided in future cases?
Personally, I would feel very uncomfortable doing that.
I have no further questions. Thank you.
Thank you. That'll take us to Mr. Opitz
No, thank you, Your Honor.
and Evergy.
Your Honor, I apologize while they're in the process of, did I offer 334? Was it admitted?
Yes.
I thought it was, and I wanted to double check that. I apologize for interrupting.
I would also like to note for the record, we have 100% attendance by the commissioners again. Commissioner Scott Roop has joined. Is there any recross? I'm sorry, is there any cross from the company?
I'm sorry, are you waiting on me?
I saw that you were consulting.
I apologize. Yes,
Go ahead.
good morning.
Morning.
Mr. Fortson, has the hydro contract been serving customers in both states since it was entered into? And both states is Kansas and Missouri.
I can't say for sure, but I believe that it has been serving customers in both states.
And that since it was, do you have a time reference for that?
So the contract, as was previously stated, started January 1, 2014. I have no knowledge of if or when it was serving customers in both states that far back, but it's my understanding that it currently serves customers in both states.
You had some, or you said that the hydro PPA expires in December 2023. After that expiration, would there be any costs that flow through the FAC from that, regarding that contract?
I think it would ultimately depend on what is ordered out of this case.
If it is ordered that it should be included in the contract, that after it expires, would there be any costs that would flow through the FAC?
I don't believe there would be any costs that flow through the FAC, but it would continue to be in base rates, would be my understanding.
So, in that scenario, wouldn't the benefit of the contract no longer be in existence flow through the FAC?
I'm not sure I followed your question.
I'm not sure I did either. We'll go on. And you spoke about a black box settlement. Again, I don't want to get into specific settlement negotiations. But after a black box settlement, wouldn't there have to be in a rate case, wouldn't there have to be an FAC tariff? And that would have a base factor that comes out of the settled rate case?
There would be an agreed to base factor that would be in the tariff sheet.
And wouldn't there be a calculation to support that base factor?
I would say I believe there typically is, but there doesn't have to be.
Well, then how does that get set?
So I think just like with anything in a case, you can black box to a base factor number.
So To your knowledge, was that base factor included in that black box settlement agreement?
From 2018?
Correct. The stipulation marked 332 that you were discussing earlier.
Can you repeat that one more time?
Was the black box settlement, was I think you testified that the base factor could be in that black box settlement. Was that included in that stipulation?
I can't say for sure, but I would assume there was a base factor that came out of that agreement.
Right, you need that base factor in order to get the FAC tariff after the case is concluded, right?
Right.
And there would be calculations somewhere to support that base factor?
Parties could have work papers to support calculations of a base factor, but I can't speak specifically to how that base factor was calculated in that case.
Well, I can hand you that exhibit, that stipulation that you reviewed, and could you point out to me where that base factor has been stipulated to?
If you can provide it, I don't have it.
Sure. Can I approach, Your Honor? And I'm handing the exhibit, what's been marked by public counsel, exhibit 332.
And you wanted me to find the base factor that was included? Would it be possible to? Okay. Yeah, on page 7, it does explicitly state which base factors would be used.
Okay. Let's take that back.
Okay.
Let's go to your rebuttal testimony, please.
Okay.
Could you go to page 12?
I'm there.
And do you see where you're discussing the company's last rate case? And you say the company agreed to exclude the costs and revenues associated with the hydro PPA from the company's FAC calculations?
That is my testimony, yes.
And then on lines 7 to 9, you state that the stipulation removed costs and revenues associated with the hydro PPA from the company's FAC?
Yes.
And you say it was silent on further cost recovery?
Yes.
Then at lines 10 and 11, you indicate that staff did not include the costs and revenues associated with the hydro PPA in its calculation of Evergy Missouri Metro's variable purchase power expense in the rate case. Do you see that?
I do.
And the calculation of variable purchase power expense that you reference, is that the calculation of the company's base rates?
The base fuel rates.
Base fuel rates? Okay. So where would I find in your testimony the reason for this removal?
I think previously in that paragraph, the staff's understanding that this PPA is not needed to meet Missouri Res. It was, as previously stated, entered into for Kansas Res. So those were reasons that staff used to justify excluding those costs and revenues.
Okay. Were those the only reasons?
I mean, I didn't go further into it, but whether it goes without saying or not, it's not needed to meet Missouri res. It was entered into to meet Kansas res. So staff in its review found no benefits to Missouri customers for this PPA.
But I thought you testified earlier that you agree that the PPA was serving Missouri customers.
Serving customers, but that doesn't lead to directly to benefits for those customers.
But if it's used to serve customers, then the customers should pay for the costs of the PPA, and the associated revenues should be offset from those costs.
So it was entered into for Kansas customers, and it's if it is being used to serve Missouri customers, if the costs are exceeding revenues and there's no benefit, and the PPA is not needed to serve Missouri customers. Even if it's being used to serve customers, it does not need to be used to serve Missouri customers.
But you did agree that it has been used to serve Missouri customers. So shouldn't the costs be included in what the company has to recover from customers?
Objection asked and answered.
Maybe rephrase?
Well, Mr. Fortson, since you removed the costs and revenues from the hydro PPA from base rates, did you replace it with any costs and revenues for energy needed to serve Metro's customers in the absence of that hydro PPA?
I can't specifically speak to staff's fuel model, but I don't believe there was a replacement, nor do I think there is a need for a replacement if the PPA is not needed to meet customer load in Missouri.
But you did testify it was actually serving load.
Objection asked and answered.
I'm
I'm going to allow it.
So if it is serving load, then shouldn't there be something in the FAC best rates that compensates the company for this use to serve load?
But the PPA is not needed to serve load. I mean, if the company chooses to serve Missouri customers with that PPA, that's their choice, but it's not needed to serve Missouri customers.
So if customers are being served, whether the company chooses or not to use the PPA, but in fact they are, the company should just be out of luck as far as recovering the cost of that contract?
The customers are currently out of luck paying for when the costs exceed the revenues for this PPA.
If fuel prices have been going up, is the PPA ever, fuel prices have been going up, is the hydro PPA ever in the money?
At the contract price as currently set, I doubt it. If it is, it will be very seldom.
Okay. Would you agree that by staff removing the costs and revenues from the hydro PPA from the base rates, that you've turned this PPA into a non-regulated contract because customers are no longer paying for it?
I'm not sure I followed that.
Objection calls
again.
for a legal conclusion.
Can you repeat it or restate it?
Would you agree that the staff of the commission has turned the hydro PPA into a non-regulated contract because it's removed the costs and revenues and customers are not paying for it under staff's proposal?
I don't think I would. I mean, it would still be, it could be recovered from Kansas customers and be a regulated contract.
But as far as serving Missouri customers, it would be a non-regulated PPA.
It's difficult for me to agree with that if we're ultimately just saying it should be regulated in Kansas and not used to serve Missouri customers.
Just a moment, Your Honor. Mr. Fortson, does the staff or the Public Service Commission determine what gets regulated by the Kansas Corporation Commission?
No?
Just going back to, I agree this is a repeat, but you did say initially that the contract, hydro PPA contract does serve Missouri customers. Why should customers get the megawatts for something that customers aren't paying for?
So first, to clarify, I would say that I believe it can be used to serve Missouri customers. So just to clarify that, and then can you repeat that second part of your
Well,
question?
if it does get used to serve Missouri customers, to me, customers aren't paying for it. So why should they get those megawatts if they're not paying for it?
You mean if they're not paying for it based off staff's recommendation?
Well, staff took the costs and revenues out. So to me, that means they're not paying for it.
So the company can choose to not serve Missouri customers with that PPA and serve Kansas customers with it.
I think that's all I have. Thank you.
Are there any commissioner questions for Mr. Fortson? And a reminder, if you're on the phone, it is *6 to unmute. Any commissioner questions? The bench does
No
have...
questions, Judge.
Thank you, Commissioner Holzman. The bench does have a couple questions. Evergy's contract extends to 2023, and staff's recommendation is to remove it from the base rates. How do you propose that the company end that contract?
I don't think they need to end that contract. I think they can still adhere to that contract by serving Kansas customers through that contract.
Okay. What if this was a utility that did not have a second jurisdiction to say, go collect from those customers, and they purchased a PPA that later in its term appears to be quite uneconomical? Would staff's recommendation be the same?
I don't know if it would be the same. I think it could be very similar. As a part of my direct testimony, I think that gets to your example of I testified to other PPAs that Evergy is currently contracted with, and many of those have costs that exceed revenues. So staff recommended in this case a provision for going forward and how that, those costs would be recovered. So I think it would be case by case, and there are different provisions that any party could recommend, but that staff would likely recommend to try and minimize the costs that have been recovered by customers for non-cost-effective PPAs.
And I'd like to follow up on a question by Mr. Kleiser. He asked you about the timing of the expiration of this contract, that it expires in 2023, which will be outside of the test year, which means that if the company does not come in quite quickly for a general rate case, that if this is included in base rates, it will continue after the expiration of the contract. Can you tell me, does that violate any law?
I do not know.
Okay, I understand that was a legal question. Thank you all for not objecting and making me overrule myself. That will take us back to recross and then finally redirect. Mr. Kleiser.
You were asked a question from the bench regarding what if this was a company without a second jurisdiction, which is slightly concerning to me. Staff's recommendation in this case is based on the fact that the company entered into this PPA to serve Kansas, correct?
Correct, and that's, if I may, that's why I tried to kind of qualify that it would be case by case. But in this particular instance, our recommendation was based off the signing of a contract for Kansas res requirement.
If Evergy didn't have a second jurisdiction, they would not have entered into this PPA at all, correct?
Very likely would not have.
And to your knowledge, they can fully recover the cost of this PPA in Kansas, correct?
That's my
I'm going to object,
understanding.
calls for speculation.
Overruled. I'll allow it.
I think the witness answered it, but for the sake of the record, you probably should repeat, I guess.
Go ahead.
Yeah, my response was that, repeat your question again.
Oh dear, now I can't remember the question.
The exchange was paraphrased, they can recover in Kansas. Answer, yes.
Well, yes, that would
It's
be my
his understanding.
Yes. Thank you.
Sorry to speak over everyone. Go ahead.
No, thank you. That saved me the trouble of remembering. That was my only question, so I'm done. Thank you.
Mr. Opitz.
No, thank you, Your Honor.
Evergy.
None.
And staff.
Just a couple questions, Your Honor.
Go ahead.
Just to clarify, if the contract is no longer applicable or renewed, will the hydro be within the rate base?
I'm sorry, can you say that one more time?
If the commission orders it to be, or to include the hydro, but the contract is no longer renewed, would that still be in the rate base after, or within this case?
It's my understanding it would be.
Now, you've seen Exhibit 332,
Is that the stipulation?
correct?
I don't have it, but I have,
The non-unanimous partial stipulation agreement.
I'm aware of it.
And you,
Oh, thank you.
in page 7,
I'm there.
now those numbers they're included in the black box, is that correct?
Correct, that's how I understand it, yes.
Now, can you define basic rates?
Basic rates or base rates?
Base rates, sorry.
Base rates. In general or high level, I would say base rates are the rates charged to customers on their bills.
And can you define what basic fuel rates are?
Base fuel would be the amount of fuel within the base rates that was set at a normalized level for the company to recover.
And for the commission, can you define what in the money means?
Simply put, I would say revenues exceeding costs.
Now, are we regulating the hydro contract by excluding it?
I don't believe so.
Are you aware are you aware of the renewal period for the hydro contract?
I believe I've seen that somewhere. Yes, I believe so.
Do you know if it's been renewed?
I do not know if it's been renewed. I've not heard that it has or what the status of any renewal would be.
Okay. No further questions, Your Honor.
Thank you. That will excuse Mr. Fortson from the stand. We are going to take a break. It is 10:12. Please be back here at 10:30. 10:30.
Your Honor, can Mr. Fortson be released subject to recall on the PC issue and remind him he's still under oath?
Yes. We are at recess and off record. And go back on the record, the time of recess having expired. Were there any more staff witnesses?
Yes, Your Honor.
Go ahead.
Yes, Your Honor. Staff calls Sean Lange.
Mr. Lange, please come on down to the witness stand. Mr. Lange, remind me, have you testified in this case already? Okay. Do you solemnly swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. Mr. Stacy, your witness.
Thank you, Your Honor. Would you please state and spell your name for the record?
My name is Sean, S-H-A-W-N, middle initial E, Lange, L-A-N-G-E.
And by whom are you employed?
I am employed by the Missouri Public Service Commission.
And what is your position there?
I am a senior professional engineer.
Have you prepared and filed testimony in this proceeding?
I have.
Specifically, direct testimony on June 8, 2022, as set forth in Exhibit 216.
Yes.
Rebuttable testimony, public and confidential, filed on July 13th, 2022, as Exhibit 244.
Yes.
And surrebuttal testimony on August 16th, 2022, as Exhibit 266, public and confidential.
Yes.
Do you have any changes or corrections to make to any of those documents set forth in Exhibits 216, 244, or 266?
Not to my knowledge, no.
If I were to ask you the same questions on those documents today, would your answers be the same?
Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes.
Your Honor, I offer Exhibits 216, 244, public and confidential, and 266, public and confidential, to be admitted into evidence.
You've heard the motion by counsel. I will combine all of the requests into one. Are there any objections to the admission of the aforementioned exhibits? Hearing none, they are so admitted. Go ahead.
Thank you, Your Honor. Staff tenders this witness for cross-examination.
Thank you, and that'll take us to Mr. Kleiser for cross-exam.
Your Honor, I would like to mark another exhibit. This should be the last one of the day for me. It should be 335 by my counts.
So marked.
I will be standing up to disperse. Staff's EMS run prepared by Mr. Lange. It was marked as confidential by staff. Does the company make what our number is confidential?
In this case?
Yes.
I'll need to check on that.
I will treat them as confidential then, and you go ahead and check. Yeah.
I can ask now, but
Go ahead. I'll lay the foundation.
Before we go on, just a heads up, Mr. Kleiser, this is one I'm going to get in trouble for because it's just a single page. If you can describe what the single page is, I'm just reading off of the bottom, and it concerns me that it's a part of a larger document. I'll stop there and let you go ahead.
I'm actually not aware of that, so let's dig into that a bit. Let's start with Mr. Lange. Well, good morning, Mr. Lange.
Good morning.
Can you identify what this is?
This looks to be my work paper. This is the variable fuel and purchase power work paper for surrebuttal. That's what
I believe it is your
True up.
surrebuttal,
Yeah.
or
let me verify because I have them here.
If I could ask everyone, both the witness and Mr. Kleiser, to move the microphones, please. Thank you so much. I apologize.
This looks like my, Sir Rebuttal work paper.
These are the work papers that you prepared for Sir Rebuttal relating to the fuel run performed by staff for Evergy Metro. Is that
Correct.
correct?
Correct.
Okay. Now, this was just approached to me, and I honestly was not aware of this. Are there additional pages to this document?
The way the spreadsheet is set up, there are additional print areas, but as far as information in those print areas, there isn't any additional information, if
Okay.
that makes any sense.
I have no problem, by the way, if the commission later seeks to cure or anything. I was not my intention to exclude information. All right, this document has been marked confidential, and I am requesting clarification from Evergy regarding the extent to which I can cross. If necessary, I will attempt to avoid any confidential information to avoid having to go in camera. Yes. That's what I figured. Yes, I will stay away from all the pricing. Mr. Lange, I'm going to ask you some questions, and my questions will be related exclusively to the column labeled MWH at the top. Please do not reference anything related to the prices on this page, as that is confidential. So for any reason we get into that, please do not reference those pages. Judge?
The first MWH column is what you are requesting, not the third that is $/MWH.
Correct. I apologize. Yes, it is the first column labeled just MWH.
Go ahead.
For the record, MWH would be megawatt hours, correct?
Correct.
All right. So if you could find the row labeled total resource cost on this work paper, it's about, I'd say, 3/4 of the way down the page.
Yes.
You would agree with me that that is what this model has determined to be the total amount to be sold into the SPP market, correct?
That is what has been modeled as being sold into the SPP market over the period that was looked at, yes.
Correct. And the row below it, EMM load, just for clarification, EMM would be Evergy, Missouri Metro, correct?
That is actually Evergy Metro total load.
Okay, so that line designates Evergy Metro's total load, both Missouri and Kansas.
Correct.
Now, under the total resource cost, and I'm going to round up, we see, well, actually, I'm going to round down for the sake of ease, 21 million megawatt hours, rounding down, correct?
Correct.
And under the total Evergy Metro load, we see 15 million megawatt hours, again, rounding down to the nearest million, correct?
Correct.
And if I go below and I see the net non-firm purchase within SPP, that's rounding down at 6 million, correct?
Correct.
And that designates, or rather identifies, that Evergy's available generation exceeds their load requirement by 6 million megawatt hours, again, rounding down, correct?
I would say Evergy's generation as dispatched in the model exceeds their load as shown in the model by that much.
Fair enough, thank you. Moving up at total owned generation, we see that that is 16 million, again, rounding down to the nearest millionth, correct?
Yes.
And I don't want to try and paraphrase what you just said, but you would agree with me that looking at just their owned generation, Evergy, Missouri exceeds their load as modeled. And again, reflecting however you want to explain that.
As staff modeled it, yes.
Now, if I find the CNPP ID hydro on this model, it is shown in the collection of contract purchases, correct?
Correct.
And it is 300,000 megawatt hours, rounding down to the nearest 100,000th, correct?
That is how staff modeled the amount of megawatt hours, yes.
And if that amount were removed from this model, Evergy would still have load in excess of its, sorry, it would still have generation in excess of its load requirements, correct?
As modeled, yes.
A question was posed earlier to staff witness Mr. Fortson by Evergy witness, and I'm going to paraphrase here, about needing, if staff removes the cost and revenues from the PPA, doesn't the company need to be compensated for the megawatt hours being supplied to customers? As I understand this, you would agree with me that the company can fully remove the megawatt hours being supplied to Missouri customers at no detriment to Missouri customers. Let me, sorry, back that up. Say again. You would agree with me that the company can completely remove the hydro PPA megawatt hours and still have enough load or generation to meet its load requirements?
As modeled, yes.
As modeled. Does fuel and purchase power costs, you would agree with me that fuel and purchase power costs decrease with the removal of a PPA, correct? Actually, let me back that up and re-clarify. Apologies. You would agree with me that the fuel and purchase power costs that you modeled would decrease with the removal of the specific hydro PPA in question here?
If you include it in totality and remove it, yes, there is additional costs, fuel costs that are removed.
I have no further questions, thank you. Oh, but I do move for the admission of 335 as a confidential exhibit, sorry. I would offer the title work papers, or, sorry, I would offer the title surrebuttal fuel run work papers of Mr. Sean Lange.
You've heard the motion by council. Does anyone object to the admission of Exhibit 335, both the public version, which will state that the exhibit in its entirety is confidential, and the confidential version, which is the one page circulated?
No objection from staff, Your Honor.
Hearing no objections, it is so admitted. Go ahead.
And as I said before, I have no further questions. Thank you.
I missed that. And let's go to Mr. Opitz
No, thank you, Your Honor.
and the company.
Mr. Lange, good morning.
Good morning.
Let's stay on confidential exhibit 335.
Okay.
Would you have prepared a similar EMS run in the last rate case?
I did not prepare an EMS run. If you're asking, did I prepare another set of work papers that resemble this in the last rate case? Yes.
Do you recall if the hydro contract was included in your EMS run in that case?
In the EMS run, I can't speak to the EMS run.
In the document that you prepared?
In the document that I prepared, I believe it was included in that case.
And then this exhibit 335, it reflects that the hydro contract is removed from staff's case, is that correct?
We removed the costs and revenues associated with the contract, or attempted to.
And then Mr. Kleiser was asking you about the fact that Exhibit 335 shows that the company has is long on generation. Do you remember those questions from Mr. Kleiser?
I do.
Is it possible that there are things that would occur in the Southwest Power Pool that would take the company from being in a long position to where the company would need to purchase power?
There could be.
Would one of those things be when SPP experiences operating conditions where Evergy units may not be dispatched?
I'm sorry, could you
Well, you said there could be instances where the company would need to purchase, and I was trying to get some examples of that. Could there be times when the company generating units would have D rates,
there could be.
or what other instances would there be where the Evergy units may not be dispatched?
There could be transmission outages, that congestion issues, perhaps. There can be a lot of different scenarios that could cause something like what you were suggesting.
Thank you, Mr. Lange.
And that'll take us to redirect. Oh, I am skipping ahead. Are there any commissioner questions for Mr. Lange? All right, hearing none. The bench does not have any questions. That will take us to recross. Redirect. Staff.
Thank you, Your Honor. Is Kansas and Missouri both modeled in your fuel run?
They are.
Is Evergy Metro's generation dispatched by SPP?
Yes.
Is the fuel model designed to dispatch based on modeled market conditions?
It is.
Are the possible future instances within the test year that you just testified to?
I'm sorry, can you?
You testified to possible future instances. Those aren't within the test year, correct?
They are, well, I'm sorry, are you asking future instances of, like we were discussing, the Council for Evergy regarding what could occur that could cause generation to not generate?
Right. That's,
we do model a certain level of forced outages and planned outages in our fuel model. So we do take into account some level of forced outage and planned outage that we expect to occur on a normal basis.
okay. Now, if congestion issues occurred, would the Nebraska Hydro benefit the grid for Missouri?
I'm sorry, can you, congestion issues for the Nebraska Hydro benefit the grid?
If there's congestion issues other than with the hydro, would the Nebraska Hydro benefit the grid?
The modeled costs for the hydro is in excess of the revenues that we modeled for the hydro.
Nothing further, Your Honor.
Thank you, Mr. Lange. I believe that brings up Office of Public Counsel's next witness.
Would you like me to call Ms. Mantle to the stand? Oh, never mind. I call Ms. Mantle to the stand.
And remind me, you have not testified in this. Thank you. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please have a seat. Mr. Kleiser.
Good morning, Ms. Mantle.
Good morning.
Can you please state and spell your last name for the record?
My name is Lena M. Mantle, M-A-N-T-L-E.
And by whom are you employed and in what capacity?
I'm employed by the Office of the Public Counsel as senior analyst.
And did you prepare or cause to be prepared testimony in this case that has been pre-marked 300 for the direct testimony on revenue requirement, 301 for the direct testimony on rate design, 302 on the rebuttal testimony, both public and confidential versions, 303 for the surrebuttal testimony, 304 for the true-up direct testimony, both public and confidential, and 305 on the true-up rebuttal testimony.
Yes.
Do you have any changes you need to make to those testimonies?
No.
If I were to ask you the same questions posed in those testimonies today, would your answers be the same or substantially similar?
Yes.
The answers you gave are true and correct to the best of your knowledge and belief?
Yes.
This time, Your Honor, I would offer exhibits 300, 301, 302, 303, 304, 305, and I can relist what each of those are if necessary.
You heard the motion of counsel. As is my habit, I will combine all of those questions into one. Are there any objections to the admission of the aforementioned exhibits onto the hearing record?
Judge, we do have a motion to strike pending on Exhibit 305, which is the true-up rebuttal. I will just stand on the objection. It lists at the bottom of page 2 the specific pages and lines that we would object to.
I recall that. I am prepared to rule on that now. Mr. Kleiser has graciously responded in writing as requested by the commission. Thank you. Does the company have any response to Mr. Kleiser's response?
We'll just stand on the objection, Your Honor.
Thank you. The objection is overruled. The testimony is admitted.
I tender the witness for cross-examination. Thank you.
That'll take us to staff. Mr. Stacy.
Thank you, Your Honor. Can you define base rates?
Base rates are the rates that are determined using the revenue requirements set in the case. So what the rates that are designed to collect the revenue requirement.
Now, is the hydro PPA needed to meet Missouri res compliance?
No, it cannot meet Missouri res compliance because the generators are 16 megawatts and Missouri statute only allows generators less than 10 megawatts.
Now, can the hydro PPA be used to meet Missouri res compliance?
No.
Now, is the hydro PPA needed to meet Evergy Metro customer load?
No.
Do you know if there are any benefits to Missouri customers based on the Nebraska hydro PPA?
No, there are no benefits that I can think of.
Nothing further at this time, Your Honor.
Thank you. Mr. Opitz.
Ms. Mantle, earlier this morning, counsel for the company asked staff's witness whether the hydro PPA was in the money, and I can't remember his exact answer, but can you explain to me what in the money would mean in the context of a PPA?
In the money would mean that when it was run, the cost for that megawatt hour was less than the revenues received from SPP for that megawatt hour.
Have you done any analysis to determine whether this PPA is in the money?
Yes, I've looked at specifically the 12 months ending May 31st, 2022, which was the true update in this case.
And I guess, so you looked at that, so what was this PPA in the money?
No, it was not. The cost in those 12 months was, and I would give you the numbers, but the reports themselves are submitted as confidential.
Are those numbers in your testimony in this case?
No, they are not.
So these numbers are in the reports that are filed where?
These are in the FAC monthly reports that are submitted to the commission through EFAS.
And I guess you're not able to answer because you believe that information is confidential, what you've estimated the cost of this PPA is?
I'm just being cautious because it is confidential.
It is confidential, I guess. I guess I'm interested in hearing what her analysis was, Your Honor. I know there was a day where we were reluctant to go in camera, but I guess I'm interested in learning what that analysis showed. So I guess I'd ask to go in camera so we can learn that figure.
Before we do that, can we,
Yeah, let's, please, counsel, go ahead and consult. We'll stand at ease for a moment. Okay, let's see where we're at. Oh, I'm sorry. We're still consulting and still at ease.
Your Honor, I'm told the company believes that the number would be confidential, so we may have to go into in-camera proceedings.
Okay, I have made the commission's reluctance to go in camera, which means
Honor?
out of the public view earlier in this case. Mr. Kleiser.
I don't mean to get in between anybody. I apologize. The numbers that I believe she was planning to testify are included in a work paper. Can we late file the work paper as a confidential exhibit, and would that be acceptable?
I also have a potential solution, Mr. Opitz, if you want to.
That would be I mean, I'd prefer to know now, but that would be acceptable if that's the solution.
I think, and I'm guessing, what Mr. Opitz is after is to establish on the record that the costs exceed the revenues. And You also want to put a number on that.
Yes, I mean, to the extent that's what she was going to testify to, but I don't know what.
Right, no, that's also my assumption. I haven't heard any witnesses yet object that that is not the case. So I was just offering that maybe that could be the form of your question. And that would get your answer on the record. And then as to the actual number, we'll look at that in a late filed exhibit. I offer that just as a solution.
That's acceptable to me, Your Honor.
Okay, it's your witness. Go ahead.
Ms. Mantle, do the costs of this PPA exceed the revenues that come from the PPA?
In every month in the true-up period ending May 2022, the costs were greater than the revenues.
Thank you. That's all the questions I have, Your Honor.
Thank you, sir. That takes us to the company.
No, thank you.
Thank you. We will ask the commissioners, and again, for the record, we do have all 5 commissioners in attendance today. Are there any commissioner questions for Ms. Mantle?
No question, Judge.
Thank you, Commissioner. Hearing none, the bench does have a few questions. I would like to refer you to your rebuttal testimony, please. And I'm going to be asking about page 6, lines 12 to 18.
Page 6, lines 12 through
18.
18. I'm there.
That testimony describes the hydro PPA entered into by KCP&L, which we all understand to be Evergy Metro's predecessor, and then it was entered into that contract in 2014 to meet the renewable energy standards, which is the RES, requirements of the state of Kansas. Do you have evidence to support that statement?
That would be the, and I'm not sure what the exhibit number was. It would be the one that had the 2 pages, and then with the attachments that were confidential. OPC data request 8002.
For the record, I have that as 333.
Thank you. That matches my records.
I would also say, in the confidential section, there is a presentation provided that presents, it was from KCPL. The first page is a Kansas statute, and then the next, or that, yes. And there, in the DR response, they didn't say who that was presented to or the date, but it was provided with that DR, and it does discuss how it would meet the Kansas RES, but could not meet the Missouri RES.
We're going to stay on that exhibit. Do you recall that your surrebuttal testimony in the 2018 rate case, which is file number ending in 0145, do you recall that your surrebuttal testimony in that case included Schedule LMM-S-4C, which is a portion of KCP&L's response to OPC's data request 8002, asking for all documentation regarding its initial decision to enter into the hydro contract?
Yes, and I have that testimony in front of me.
Thank you. I'm sorry, that was leading into my next question. Thank you. Would OPC be able to provide your sir rebuttal testimony in case number ER-2018-0145 as an exhibit?
We can make it a late filed exhibit, yes. It would be marked 336 by mine.
We will follow the same schedule for all other late filed exhibits, and we will give the company or anyone else who has objections until Wednesday. Those dates, while we are talking about them, I think I said September 6th earlier, and I would like to make sure that that is corrected. I will issue a notice or an order reciting these dates.
Your Honor, the request is for the surrebuttal testimony filed by Ms. Lena Mansell in case,
0145.
does it, and 0146? Or, well, if you, did you file the same testimony in both dockets?
Yes, it has both dockets on the cover sheet.
Excellent. I'll just take one. It's a combined record for those listening that may not be familiar. That sometimes parties will file in a case like this where we have two actual separate cases. They will file one document with both case identifiers on them. This is that case as well. This is an example of that. So 336 will be the commission requesting Ms. Mantle's testimony from 0145, your sir rebuttal testimony. Thank you. That's all the questions the bench has. That takes us to recross examination, and that will start with staff.
I think I just have one question, Your Honor. What rows and columns of your work papers you just testified to would be applicable? Where would the commission look in those work papers?
To find the cost and revenues of the hydro PPA,
Correct.
they are not in any current work papers. I think we're going to, I guess maybe that's a good place to stop. They aren't in my current work papers. I came up with those numbers earlier this week.
Mr. Kleiser.
We had offered earlier when we were having that back and forth about making it a late file exhibit. I will take that up at the end of redirects just to save time.
No further questions, Your Honor.
Thank you. Mr. Opitz.
No, thank you, Your Honor.
And Evergy.
So it's not really redirect, just wanted clarification that this late filed work paper of the costs of the hydro contract is something that you're going to create. It's not something that exists today. Is that what I'm hearing?
It exists today. It just has not been provided to any of the parties. I have the spreadsheet. I just have not
It wasn't
provided.
work papers you'd used for the filing of any of your testimony previously in the rate case. Is that correct?
I did not have these specific numbers in front of me. I was aware that it was typically, I believe the only month that it actually had revenues greater than cost would have been February of 2021.
Okay, but that's just trying to understand what the work papers are going to be, and I'll look at it when they get filed.
I understand, and I want to make very clear for the record, because this does seem to be a little off of what my understanding was, at any rate. This exhibit has not been admitted and is still open to objections and will be decided on its admission at a later time. But I do note Mr. Steiner's point that this was prepared after your testimony in this case.
That
And
is
I
correct.
heard your answer that you did not have those numbers until then.
That is correct.
Okay. Mr. Steiner, any further cross-examination questions?
No, thank you.
That takes us to redirect. Mr. Kleiser.
You were asked, good morning, Ms. Mantle.
Good morning.
You were asked a question from the bench regarding the testimony you filed in the 2018 case.
Yes,
And your understanding is the 2018 case was settled by a stipulation, correct?
correct.
And with regard to the OPC's position in the 2018 case as it relates to the hydro PPA, how was your position, how did you understand the OPC's position with regard to that stipulation?
The OPC's position was that the hydro PPA costs were not included in revenue requirement and not included in the FAC.
You were asked a question by staff to define base rates.
Yes,
I'm going to hopefully make this not more messy, but with regard to the FAC, there's a net base energy cost and a base factor. Now, the base rates you were referring to was a different thing. Can you just, so that those three things are defined separately and clearly, can you explain what each of those three are and make sure there's no inner confusion?
I will try. And we've tried to come up with a better term than base rates. Sometimes I call them permanent rates just because they don't change between rate cases. And those are rates that are set to recover the revenue requirement. Part of the revenue requirement is fuel and purchase power cost and other costs that are included in the FAC. Those are normalized in a rate case. They're included in the revenue requirement, and they should be, those costs and revenues that are included in the revenue requirement that are part of the FAC are used to calculate the base factor of the FAC. And the base factor is that cost, that normalized cost that's included in revenue requirement divided by the normalized kilowatt hours for that case. So you get a cents or dollars per kilowatt hour. That's your base factor. And going forward, that's considered how much of that permanent rates is paying for fuel in any given month. So you can take the actual kilowatt hours, multiply it times the base factor, which is a $1 per kilowatt hour number, and you have the amount that was collected to cover fuel and purchase power, FAC. Now, outside that, we have the actual FAC cost and revenues. What the FAC rate is based on is the difference between that actual that was incurred and what was paid through the permanent rates. And the permanent rates is that amount is that base factor times the kilowatt hours. So we have actual costs, we have the costs that were included in the rates. The difference between that, 95% of it is either returned to the customers or collected from the customers. I think I got all of your terms that you asked for there.
Just to make sure, the net base energy cost is the cost of energy that is included as a component of base rates that accounts for fuel?
Fuel and revenues that are part of the FAC, yes.
Okay. I wanted to make sure that those were clearly defined terms. Hopefully, I haven't created more confusion. I have no further redirect. Thank you.
Ms. Mantle, thank you very much. You are excused. I do not have any further witnesses on this topic. I will then take us to our next topic, which is related, Roman numeral 6, fuel and purchased power. And Mr. Kleiser.
Sorry, before we go up on that, so I know there's been discussion of this. The commission would like Ms. Mantle's work papers relating to the hydro PPA as a late filed exhibit? Or, no, we were offering that.
I was asking for Sir rebuttal testimony.
Right. There
Okay.
was discussion regarding the question posed by counsel for MECG. We
I-
had offered that as a way to provide the numbers without getting into confidential information.
Can we call them something other than work papers?
I am happy to call them whatever the commission would like.
Ms. Mantle's later calculations.
Certainly.
Thank you.
Those would be late filed as Exhibit 337.
Tell me what 336 is. Oh, 336 is for Sir rebuttal.
Yes. And you would like those titled Ms. Mantle's late calculated?
I want to distinguish between the work papers that we're all gonna, okay, so I don't want to
Whatever
create a
name.
name that says it's this whole separate new thing, but it's not really.
I'm fine with whatever name you want, just what name would you like?
Ms. Mantle's late calculated
Sure.
something. Feel free to shorten that, otherwise adjust it. I just want it distinguished from, quote, work papers.
Completely understood. Thank you. Sorry for the interruption.
Nope, you're good. We are going to Roman numeral 6, fuel and purchase power. Does any party wish to make many opening statements, beginning with the company?
Judge, are you talking about what I would call the PISA deferral issue, or are you talking about something else on fuel and purchase power?
I believe it is the PISA issue on my cheat sheet, which is taken from whatever attachment was to the first stipulation stating what issues were left. It should be sub 26.
In that case, Judge, yeah, I would have a brief opening statement on the PISA issue, and I think we're done with the hydro issue.
I agree.
Okay.
Yes, let's move to the PISA issue then. And Evergy will start with its mini opening statement. Go ahead, sir.
Thank you, Judge. May it please the commission. Again, for the record, this is Jim Fisher. The next issue involves the plant and service accounting deferral issue, and I'll shorthand that as the PISA deferral issue. It only affects the Missouri West case. This issue is discussed in the Sir rebuttal testimony of Darren Ives and the testimony presented by staff witness Brad Fortson and also the public counsel witness Lena Mantle. A little bit of background. Evergy Missouri West elected plant and service accounting in December of 2018 and therefore is governed by section 393.1655. Sometimes that's just referred to as the PISA statute. Under the PISA statute, there is a requirement that the company which elected PISA accounting must not increase its rates by more than 3% annually. And with the timing of this case, the statutory cap will be a cumulative compounded increase of 12.55% up to the effective date of the new rates in this case. And I'm going to shorthand that too. I'm going to shorthand the compound average growth rate cap to just the statutory cap. Brian, could I have slide 2, please? The provisions of section 393.1655 with subsection 5 state in effect that if a change in any rates under a rate adjustment mechanism approved by the commission, which in this case would be a fuel adjustment clause mechanism, would cause the company's average overall rate to exceed the statutory cap, the electrical corporation shall reduce the rates in an amount sufficient to ensure that the statutory cap is not exceeded. Subsection 5 of the statute also requires that any sums not recovered under the rate adjustment mechanism, which would be the fuel adjustment clause, shall be deferred and recovered in a regulatory asset in a future case, rate case. As Ms. Mantle noted in her rebuttal testimony in this case, Evergy Missouri West has proposed to defer $31 million in FAC-related costs related to the plant and service accounting to a regulatory asset for recovery in a subsequent rate case in a FAC case which was filed on July 1st, 2022. And the case number on that, the file number is ER-2022-0130. I'll probably refer to that as just the FAC case. In that case, Missouri West is proposing to adjust charges related to its FAC for the accumulation period covering December 2021 through May 2022. The full amount of Missouri West's FAC-related costs during this accumulation period was approximately $44.6 million. The reason for this deferral is to apply the rate adjustment mechanism deferral provisions of the PISA statute. This is necessary since the increased fuel and purchase power costs driven by market conditions beyond the company's control are causing the rates to exceed the statutory cap. Therefore, the company is required to defer the amounts necessary to keep the rates under the statutory cap. Evergy is following the exact mandate of Section 393-1655, subsection 5, and requesting that $31 million of fuel costs in the FAC case shall be deferred to ensure that the FAC change does not cause the company to exceed the statutory cap. Including this amount in the FAC case would cause Missouri West to exceed the statutory cap when considering the impacts of the most recent FAC accumulation period, the immediately preceding FAC accumulation period, and the effects of the overall rate increase in this case, which is driven entirely by the rate rebasing of fuel and purchase power into base rates in this rate case, as is required by the FAC rules of the Commission. Brian, let's go to 3. As you may recall in my opening statement on August 29th, I showed the Commission a slide which demonstrated the impact that increases in fuel and purchase power costs have in the case at hand, in this rate case. As I told the Commission in that opening statement, the entire amount of the increase in the Missouri West case is driven by increases in fuel and purchase power. For Missouri West, the company's rebasing an incremental $56.1 million for fuel and purchase power expense. The overall revenue requirement increase is $42.5 million based upon the current settlement document. Now, to emphasize, this means that all other components of the revenue requirement in this case, besides the rebased fuel costs, result in a $13.6 million reduction in revenue requirement in this case. Let's go to slide 4. Now, this slide shows the impact of this general rate case, which is being entirely driven by the rebasing of fuel, and it has an impact of 7.5% on rates. The FAC accumulation period, which I've identified as Part 1, it's the June through November 2021 period, that accumulation period fuel cost increases in the FAC case is 5.2%. And then the second period, the FAC accumulation period of December 2021 to May 2022, that fuel cost increases the account by 4.4% increase. So the fuel increases are causing the rates to increase a total of 17.2%, which would exceed that 12.55 statutory cap that I told you about earlier. And this is the reason why the company is required to defer $31 million of fuel costs to avoid exceeding the statutory cap. The 17.2% increase depicted on that slide exceeds the 12.55% statutory cap. And that's before consideration of any non-FAC-related cost increases or decreases experienced by Missouri West since its last general rate case in 2018. Now, importantly, as I've noted earlier, the rate increase resulting from the company's general rate case, this case, would be nowhere close to exceeding the PISA statutory cap, and we would not be discussing PISA caps at all but for the impact of the fuel and purchase power expenses in this case. The company's FAC-related costs are significantly impacted by external factors outside of the company's control and have been subject to inflationary pressures not seen for many years due to the extraordinary events of the pandemic and Russia's war in the Ukraine. Now, under these circumstances, Missouri West is following the PISA statute and has appropriately requested the deferral of the fuel and purchase power costs in the FAC case, ER-2022-0011. Further, the proposed deferral in that case is also consistent with the paragraph of the Commission's FAC rules, Roman numeral 11, and given the extraordinary circumstances surrounding the company's fuel cost increases. Now, if the Commission accepts the company's position, it would not penalize the company for events outside of its control. It would follow the intent of the state to not penalize companies electing PISA for fuel and purchase power increases under the FAC, or the rate adjustment mechanism, and it will enable resolution of this rate case without exceeding the statutory cap as a result of the extraordinary fuel price increases. So, why are we talking about this matter in this current rate case? The answer is that the Office of the Public Counsel does not want to wait until the conclusion of the FAC case, ER-2023-0011, for the Commission to authorize the statutorily required deferral of fuel and purchase power costs. Ms. Mantle argues in this case that Missouri West's proposed deferral is not necessary in the FAC case, and it should be dealt with in this current rate case. And I'd refer you to page 29 of her testimony. As I understand the Public Counsel's position, they want the Commission to provide for full recovery of the company's FAC costs in the FAC case with no deferral. They would then assert any statutory cap exceedance as a result of the Commission's order in this case, fully driven by increased fuel costs in the FAC rebase, as I've discussed several times, would be treated as a performance penalty under subsection 3 of the PISA statute. This is clearly not a reasonable proposal, Judge. Rather, if the Commission decides to not address the statutory cap exceedance in the FAC proceeding, as the company requests, it should address the exceedance in this case. However, contrary to the Public Counsel's position, it should not be addressed as a performance penalty under subsection 3 of 393-1655. It should be addressed as a deferral under subsection 5 of that statute, as the entirety of the costs leading to the statutory cap exceedance are increased fuel costs, as I've discussed. However, a deferral in this general rate case would have the effect of lowering the revenue requirement resulting from the rate request. The effect would provide for less annual revenues to the company than it should be if the deferral were addressed in the FAC case. The company would likely be inappropriately penalized under this approach for fuel increases that would flow through the subsequent FAC accumulation periods that are outside of the control of the company, and would be inconsistent with the state intent to remove the effect of FAC rate adjustment mechanism increases on the statutory exceedance of that deferral. In other words, the state has the policy that FAC increases shouldn't impact the statutory cap. They should be deferred. This is exactly what the PISA statute attempts to avoid by allowing the deferral of the fuel costs on the FAC case. It's the policy of the state that the public utilities that elect plant in-service accounting should not be penalized by fuel increases that are outside of their control, but instead, the company is required by the PISA statute to defer fuel costs without a financial detriment to the company. Now, Darren Ives will explain the negative impacts the Public Counsel's proposal would have on the company and the added complexity that the deferral in the rate case as opposed to the FAC case can create. And I'd certainly encourage the judge and the commissioners to ask him any questions that they might have related to this matter. Public Counsel filed some pleadings in the FAC case, which explains to some degree, I think, the Public Counsel's theory on its recommended approach. As I understand the Public Counsel's arguments, if the Commission decides the second FAC case, which is that ER-2023-0011 case, before it decides the general rate case, Public Counsel does not believe that the Commission can defer the fuel cost increases that come from the general rate case. Therefore, under this flawed theory, any increase above the statutory cap would be treated as a performance penalty, and Evergy would be denied recovery. However, if the Commission decides this general rate case first, and then decides the second FAC case, then the Commission would have the clear statutory authority and the obligation to defer enough fuel costs to keep the company from exceeding the statutory cap. Public Counsel's theory is incorrect. The Commission has the authority to defer fuel and purchase power costs in either case. In fact, the general rate case, as I've said several times, is being driven entirely by the requirement to rebase fuel and purchase power costs. But as I've already explained, it would be preferable to deal with the deferral in the FAC case, since it would not have a detrimental impact upon the company's financial situation. Even under Public Counsel's view, Public Counsel admits that if the Commission decides Evergy's current rate case before the FAC case, then the issue in dispute will be rendered moot. And I'd refer you to the Public Counsel's motion for summary determination, page 12. With that, Judge, I appreciate your attendance, and I'd be glad to answer any questions.
Are there any commissioner questions for Evergy? Hearing none, the bench has no questions. Let's move on to our next mini opening statement. Staff.
Thank you, Your Honor. May it please the Commission. Again, I'm Scott Stacy and counsel for staff. Here today to testify for staff will be Brad Fortson. He will testify about the PISA deferral issue. The second issue to be addressed is whether our staff's position is the PISA deferral should be dealt with in the FAC case, case number ER-2022-0129. And it should not be deferred within that case. However, staff's alternative is to defer the $31 million in that FAC case to the next FAR case. Thank you. I have no further questions.
Thank you, Mr. Stacy. Are there any commissioner questions for staff upon their opening statement? Hearing none, the bench also has no questions. We'll move on to our next opening statement. Mr. Opitz.
No, thank you, Your Honor.
And Mr. Kleiser.
May it please the Commission, John Kleiser. So this issue has become very confused by the opening of counsel for Evergy. It's actually immensely simple, and a lot of what he said does not factor into this. Let me try to explain this very simply. Evergy has an FAC rate increase case. Evergy is seeking a deferral in that case.
The OPC opposes that deferral. We have filed motion for summary judgment saying there should be no deferral. Our argument is based on a statutory interpretation issue. I am not going to try to litigate that issue before you right now. That's a separate case. You don't have to worry about it. If the commission grants a deferral, when should it be deferred to? This case or some other point in the future? That is the only issue before you. The OPC's entire position is, if the commission grants a deferral, which we are advocating you should not do and are legally not permitted to do, but if you grant the deferral, defer it to this case and not some point in the future. You may be wondering, what does it matter? And the simple answer is, if you defer it to this case right now, you A, deal with it, don't have to worry about it in the future, and B, the company can recover it at the rate of a 4% bond instead of having to defer it in the future and get a higher cost of return. You are under no obligation to consider any of the issues in ER-2022-0011 here. They're not relevant. The question of whether or not the company should or should not make the deferral is not relevant. All you have to do is ask yourself, if a deferral is made, which again we are saying you should not, when do you defer it to? Now, I will present to you my argument for why you should defer it to this case. The costs incurred were incurred during the true-up period for this case. That is the entirety of my argument. They were incurred during the true-up period for this case, they should be recovered during this case. If you order a deferral, which again we're saying you shouldn't. I may have been misled. I was trying to listen to counsel for Evergy. I could have sworn they said that they agree that you should deal with the deferral in this case, in which case we're in agreement, and I'm even more confused, frankly. But I digress. This issue is not a factual one. It's a purely legal issue, and it's entirely dependent on the outcome of the FAC rate increase case. If the commission decides no deferral in that case, this issue is done. It's gone. There's no deferral. If the commission decides the FAC increase case after it rules in this case, it doesn't matter, because you can't put it in this case. It happened later. And counsel for Evergy is absolutely correct. It is rendered moot if that's the order in which things occur. All the commission needs to do is say, if we grant a deferral, which again, I repeat, the OPC is claiming is illegal, in the FAC rate increase case, should we deal with it now or later? That's it. Are there any questions?
Are there any commissioner questions for the Office of Public Counsel upon their opening statement? Hearing none, thank you, sir. The bench also has no questions. That concludes our mini opening statements. And I am unsure of how many witnesses we have, so I will just ask Evergy to call their first witness.
We would call Darren Ives to the stand.
And as Mr. Ives makes his way to the stand, you have already been sworn in. Just to remind you and let everyone else know that it's still applicable, go ahead and have a seat. And I expect we will jump right into cross-examination. Evergy, your witness?
Yes, Judge, we would just jump right into cross-examination since Mr. Ives' testimony has all been admitted into the record in previous days of the hearing. So at this point, I would tender the witness to discuss the PISA deferral issue.
First up, we have MECG.
No, thank you, Your Honor.
And then Mr. Stacy.
Nothing as of yet, Your Honor.
Office of Public Counsel.
No questions, thank you.
Do any commissioner questions have any questions for Mr. Ives concerning the PISA issue?
No questions, Judge.
Thank you, Commissioner Holzman. Hearing no questions, the bench also has no questions. Unless I am corrected, you are excused from the stand. Thank you, Mr. Ives.
Thank you, Judge.
Evergy, if you have another witness, please go ahead and call them to the stand.
That's our last witness on this issue, Judge, and our last witness for the case, I think.
I believe staff has a witness? Question mark?
Correct, Your Honor. Staff recalls Brad Fortson.
Mr. Fortson, come on down to the witness stand. You've already been sworn in. That is still applicable. And again, I anticipate jumping right into cross-examination.
That is correct, Your Honor.
Go ahead and have a seat. We'll start with our cross. Mr. Kleiser.
No questions, thank you.
Mr. Opitz.
Thank you, Your Honor.
Hey, Jackie, could you mute that, please? Thank you. And the company. Any cross for?
No questions, Your Honor. Thank you.
Thank you. Are there any commissioner questions for Mr. Fortson? Hearing none, the bench also has no questions. Mr. Fortson, thank you very much. Does staff have any other witnesses?
No further witnesses, Your Honor.
Thank you. I believe public counsel goes next. Ms. Mantle appears to be public counsel's witness. Ms. Mantle, you have already been sworn in. That is still applicable. Go ahead and have a seat. And I again anticipate directly to cross.
Tender to cross, you're right, Your Honor.
Mr. Stacy for staff.
No question, Judge.
Mr. Opitz for MECG.
No, thank you, Your Honor.
And the company.
No, thank you, Judge.
Any commissioner questions for Ms. Mantle regarding the PISA issue?
No questions, Judge.
Thank you, Commissioner Holzman. The bench also has no questions. Ms. Mantle, thank you. You are excused. Does the Office of Public Counsel have any other witnesses?
We don't.
And I am unsure if Mr. Opitz has, he does not have any witnesses indicated by a negative shake of his head.
Your Honor, could I ask a question if you're finished?
Yes, please.
Would this be a good time to offer the admission of a lot of testimony that a witness did not appear? It'll take some time, so I don't know if this is something that Your Honor wants to deal with now, but would like to get it dealt with before the end of the day.
I would, and I'm sorry to interrupt, but I want to make sure that everyone is following along. We're going to go to some administrative procedural matters. After that, I'm going to call a lunch recess. We will come back at 1 p.m., and at 1 p.m. we'll be opening statements for the on-the-record presentation regarding the 4 filed stipulations and agreements. For the parties' information, I have received no inquiries as to specific subject matters. Yes, I do want to take in all of the exhibits. So if anyone is not interested in my recitation of numerous exhibit numbers and asking for objections, you can feel free to go ahead and excuse yourself from the hearing. Let's get into those exhibits.
Does Your Honor intend to offer them in batches?
I would sure like to, but that seems...
I was going to say that we have no objection if you want to just batch all the...
Here's what I'm going to do. I do want the numbers in the record. I am going to read only the exhibit numbers pursuant to the submitted party exhibit lists. but I do want the numbers in the record.
These are all pre-filed testimony
All
exhibits, right?
pre-filed, I'm not touching anything else. This is for Evergy Metro, file ending in 0129. I have a motion. I have a motion to admit the following exhibit numbers. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 14, 15, 16, 17, 18, 19, 20, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 43, 48, 53, 54, 85, 86, 87. Those are all for file 0129. Go ahead.
Your Honor, I believe that Exhibit 62 was not mentioned.
You are correct, and 62. Those are all in file number ending 0129. Are there any objections to the admission of those numerous pre-filed testimonies? Hearing none, they are so admitted. I recognize a motion from the company to admit the following exhibits to file number ending in 0130. This is referencing Evergy, Missouri West. The exhibit numbers are as follows: 100, 101, 102, 103, 104, 105, 106, 109, 110, 111, 116, and that is all.
Your Honor, do you have 112 admitted already?
Yes, Mr. Leddick.
Yes. Okay, thank you.
Does anyone have any objections to the admission of the four numerated exhibits that represent the pre-filed testimony in the Evergy, Missouri West file number by Evergy? Hearing none, they're so admitted. Some of them are confidential, some are not. Is that okay?
Yeah, I was just usually in the index, I can run it separate. But if I have a, if I have a exhibit list, I can do it.
The judge will be introducing an exhibit list upon the conclusion of this hearing. Excellent. We went off the record to discuss some file keeping matters. Next, I'm going to take staff for their exhibits, if I can get a nod that we're ready. Otherwise, I can go to another party, no sweat.
Yeah, I think we're ready.
Okay. I have the following exhibits. I see a motion from staff to admit the following exhibits. Again, I will read them only by number, and I will not reference names or confidentiality. The judge, as prescribed in the discussion with the court reporter, will issue a complete list of all exhibits, including their confidential or public designations, in a later notice. The exhibits subject to this question: Exhibit 201, 202, 203, 204, 205, 206, 207, 208, 210, 212, 213, 214, 217, 219, 220, 221, 222, 223, 224, 225, 226, 227, 230, 231, 232, 233, 234, 235, 236, 239, 240, 245, 246, 247, 248, 249, 250, 251, 252, 253, 255, 256, 257, 258, 259, 260, 264, 267, 268, 270, 271, 272, 273, 274, 275, 276. Those are the remaining exhibits of pre-filed testimony prepared by staff witnesses that have not been admitted onto the hearing record. Are there any objections to the admission of that entire list, which I will not repeat, that does include confidential and public versions?
Judge, I have that there are a few additional true-up rebuttal exhibits.
Hit me.
It was Exhibit 277, the true-up rebuttal testimony of Amanda C. Connor in public and confidential formats. Exhibit 278, the true-up rebuttal testimony of Kim Cox, which was just public. 279, the true-up rebuttal testimony of Jay Lubert, which was public and confidential. 280 would have been the true-up rebuttal testimony of Karen Lyons. That's just in public. 281 was the true-up rebuttal testimony of Soonjin Wong, and that was in public. And then 282 would have been staff's true-up rebuttal accounting schedules, which was also just in a public format.
You have heard the addition of those exhibit numbers by staff. Again, combining all of the exhibits into one question, unless I hear otherwise from any counsel. Does anyone have any objections to the admission of those aforementioned exhibits? Hearing none, so admitted. Office of Public Counsel. These are the pre-filed testimony exhibits of the Office of Public Counsel that have not been yet admitted into the hearing record. Exhibit number, and again, they do include some public and confidential, which I will not delineate, but the presiding officer will produce a list later on of all of the exhibits and their designations. The numbers include Exhibit 312, 313, 314, 315, 316, 317, 318, 319, 320, 321, 325, 326, 327, 328, 329, 330, 331. That is my entire list. Are there any objections to the admission of those aforementioned exhibits onto the hearing record, both public and confidential versions? Seeing none, they are all exhibited.
Your Honor,
Admitted.
I really would prefer not to do this, but as an officer of the court, I would point out that there is technically a pending motion to strike regarding Exhibits 321, 330, and 331.
Thank you.
filed
I'm
by
prepared to
staff.
rule on that. Mr. Kleiser has responded in writing to staff's motion to staff's motion. Staff, do you have any response to Mr. Kleiser's written reply?
I believe at this moment, as far as regards staff's motion to strike, which I do also believe there was an Evergy one on a distinct piece of testimony, but that the pending stipulation and agreement would render that moot. And so as far as it appears, or hopefully will be approved, I think that for now, it can be withdrawn.
Yes, thank you. I was waiting for a motion to withdraw that motion. Granted. Problem solved.
You're granting the motion to withdraw.
Granting her motion to withdraw the motion to strike. I am going to repeat my question on the exhibits because it kind of got lost in there a little bit. Any objection to the admission of the list of public council exhibits that I read off? Hearing none, they are so admitted. Sierra Club, I have all of their exhibits checked off. Renew Missouri. This is a party that's not in the room. Does any party that is in the room have an objection to doing the same treatment we just have and accepting the pre-filed testimony? I'm not seeing any objection. For Renew Missouri, the following exhibits have not been admitted, but they are pre-filed testimony. Exhibit 500, 501, 502, 503, 504. Does any party have any objection to the admission of those exhibits of pre-filed testimony by Renew Missouri? Seeing none, they are so admitted. Charge Point similarly has pre-filed testimony, Exhibit 550 and Exhibit 551. Does any party have any objection to the admission of Charge Point's witnesses' pre-filed testimony in those two exhibits? Hearing none, it is so admitted. MECG has all of their exhibits admitted, according to my score sheet. City of St. Joseph has all of their exhibits admitted, according to my score sheet. And I believe we also got MIEC's exhibits, although I do not have their exhibit list. I know we got Mr. Brubaker. I don't think they had anything else? Question mark?
I'm not certain.
Well, we did what we could.
While we're in the process of going over exhibits, can I query to ensure that 332, 333, 334, and 335 have been offered and accepted?
Yes.
Thank you.
The commission would also like to receive an exhibit, perhaps best from Evergy. The commission is interested in the revised hedging policy. My understanding is that the fuel and purchased power hedging issue is included in one of the stipulations. The commission, though, is interested in reviewing what the new revised policy is. I'm happy to take that as an exhibit, a commission exhibit number in the thousands, or give it an Evergy exhibit number. Council, your choice.
We can use it as one of ours.
Okay. 139. And again, that will be subject to our next Friday deadline for late exhibits and our following Wednesday deadline for objections.
Judge, did you say that you would issue an order on all the late filed exhibits that you're expecting or not?
Yes. Judge Woodruff is who I'm copying, and he has an excellent practice of, after the hearing, issuing a notice that lists all of the exhibits with the confidential and public, with the name, and I will certainly include in that notice or order the requested and the pending late filed that are expected in the future.
Thanks.
I have no other appropriate announcements. Anyone else?
Judge, I would inquire for the next part of the case, will the commission want a summary of all the provisions, or can I go through it fairly quickly and ask for questions? Okay, thank you.
And again, I am basing this on my history and watching prior on the records. I have received no specific areas of inquiry. I have asked twice. So the commissioners are keeping their own counsel. They may have questions. The advice I gave the other day was just high-level thumbnail. Obviously, some of the important underlying numbers are going to be important to discuss. The commission is always interested in areas of compromise, areas of customer focus, and try and get a good balance. But no, certainly not every issue.
Really quick, a question that occurred to me. I know that there is a email for the non-pre-filed exhibits. Is it the commission's, or rather the hearing judge's understanding that the pre-filed exhibits will be removed from EFIS and we do not need to send them to you? Or do you want us to send you the pre-filed exhibits?
The only pre-filed exhibits I will be paying special close attention to are the corrected ones. There's a handful we just asked for that are coming, and there was, I don't know, 2 or 3 that we've dealt with.
As a procedural matter, you do not need parties to email the pre-filed exhibits to the email address for exhibits. That's what I needed to hear.
Everything is all the same? No, we'll have our staff pull them off of EFIS, and that'll go right into the record. We don't do that until the transcript comes in, which is why I am going to produce the master list for all of our citation E's.
And then I believe this was already said in email communication to the parties, but for the non-pre-filed exhibits, there is an email address that we need to send them to.
Exhibits@psc.mo.gov. Exhibits@psc.mo.gov. We are adjourned for lunch and off the record. Thank you all. Come back at 1 o'clock. 1 o'clock.